This is one of the most powerful topics in A-level law, restrictions and police powers. This is where individual freedom meets public safety. It's a balancing act that's at the core of our legal system. And it's all about the question, how far can the police go to keep order, and when do they go too far? That's what we'll be unpacking in this session. We'll look at where the law draws the line and what happens when things go wrong. We'll explore what restrictions are allowed under the European Convention on Human Rights, what powers the police have, and what remedies exist if those powers are misused, because yes, there are ways to challenge the police if they overstep. So let's unpack this together. We'll start here. So the European Convention on Human Rights, or the ECHR, it's basically like Europe's big guidebook for fairness and freedom. It sets out the rights we all have just for being human. And the UK made these rights part of our own law with the Human Rights Act 1998. Here's the key idea. Rights under the ECHR aren't absolute. This means there are times when your rights can be restricted, but only if the law allows it, and only if the restriction is set out in law, so the police can't just make up the rules as they go, only if the restriction is necessary, so there has to be a really good reason for it, like protecting other people from harm, and finally, the restriction must be proportionate. So that basically means not going over the top or using a sledgehammer to crack a nut. Let's consider a few key examples. Article 5, the right to liberty and security. So you can only be arrested or detained if the proper legal process is followed. If the police skip any steps, it's unlawful and you could have a claim against them. Article 8, so this is the right to private and family life. And your home and your private life, they are protected. But the police can interfere if there's a solid legal reason, like investigating a serious crime. So, they can't do any random snooping. Next, we have Article 10, which is freedom of expression, and Article 11, which is freedom of assembly. So you are free to say what you think, you're free to join protests, but these freedoms can be limited if there's a real risk to public order or safety. You can't shout fire in a crowded theatre when there isn't one. So freedom of speech doesn't cover things like inciting racial or religious hatred. That's a criminal offence under the Public Order Act 1986. And the ECHR agrees it's a fair limit to protect others. All right, let's check out now what the police can actually do. So their powers mainly come from PACE 1984, and that's the Police and Criminal Evidence Act, plus a few other important laws like the Misuse of Drugs Act and the Terrorism Act. So these set specific rules for each type of power. So let's have a look step by step, and we'll start with stop and search. This is probably the police power people hear most about. It means the police can stop you and check if you're carrying something illegal, but only in certain situations. So what law are we looking at here? Mainly PACE, Section 1, Misuse of Drugs Act 71 and Terrorism Act 2000. So the police need to have reasonable grounds to suspect you're carrying stolen goods, illegal drugs, a weapon, or something that could be used to commit a crime, like a crowbar. But there are rules to stop this power being abused. And these are as follows. The police must always show you their ID if they're not in uniform, always tell you their name and police station and what they're searching for. They have to explain what law gives them the power to search you. And they have to provide a written record or tell you how to get one later. They can only ask you to remove outer clothing, like coat or gloves in public, nothing more. So to help officers remember all the steps they need to take during a stop and search, the acronym GO WISELY is often used. So this stands for grounds for the search, object of the search, warrant card, if not in uniform, identity, that means name and station, station that the officer is based at, explain the search's legal power, legal entitlement to a search record, and finally, you are being detained for the search. So this helps ensure the search is fair. It also helps ensure that it's legal and that your rights are protected throughout the process. And remember, you don't have to give your name or address unless you're actually being reported for an offence. If you're just being searched, you can stay quiet about your details. And under the ECHR, this connects to Article 5, liberty, and Article 8, privacy. And the courts have been firm. Police can't use stop and search just because they feel like it. There's a case, Roberts versus Chief Constable of Cheshire, 1999, and the court here said that stop and search must never be random or based on unfair stereotypes. Let's now consider search of premises. So searching someone's home or their property, that's a big deal. Nobody likes surprise visits from the police. And that's why the law is very clear about when and how this can happen. So the law we're looking at here is PACE, Section 8, and that's when a search is conducted with a warrant, and also Section 17, which is when the search is conducted without a warrant in emergencies. But usually the police do need a search warrant, and a search warrant is a written order from a magistrate, basically a judge, that says exactly what and where they can search. But if it's an emergency, police can enter without a warrant if they're chasing someone they believe has committed a serious crime, or they need to save someone's life or prevent serious damage, for example, stopping a fire or rescuing someone. So whenever they search, police must show you the warrant, if they have one, explain why they're there, and only search the areas and things the warrant allows. They're not just allowed to go rummaging through everything, just in case. So if the police go beyond what's allowed, your Article 8 privacy rights are then in play, and you may be able to challenge their actions. Let's move on now to arrest. So when can the police actually arrest you? Well, certainly not on a gut feeling. The law is very strict on that. And the law we're looking at now is PACE, Section 24, and the Serious Organised Crime and Police Act, 2005. So the police can arrest you if they've got reasonable grounds to suspect you're involved in a crime, and it's necessary to arrest you. For example, to stop you running away, or to protect other people from harm, or to prevent you from destroying evidence. So they have to tell you clearly that you're under arrest, as we know, and why, and that's known as cautioning you. And they're only allowed to use the minimum force needed to get the job done and no more. In O'Hara versus Chief Constable, the court said a police officer's suspicion must be based on facts they actually know and not just rumours or orders from higher up. Let's move on. What happens next? So after the arrest, you can be held in custody, in detention, but there are really strict time limits actually on how long the police can keep you without charging you. So now we're looking at the law of PACE again, but this time sections 41 to 44. So the police can keep you for up to 24 hours without charge for most offences. They can keep you for 36 hours for serious offences, but here they have to get approval from a senior officer. They can keep you for 96 hours, which is 4 days, but only with a magistrate's order. And finally, under terrorism laws, the absolute maximum that you can be kept in custody is 14 days. And again, that would only be with a court approval all the way. And while you're in custody, you have some important rights too. So you can get free legal advice. You can also let someone know where you are. You can see a doctor if you need one. And you can see the official codes of practice so you know what the rules are. And the police have to keep checking if it's still justified to keep you in. They can't just forget about you at the station. In HSU versus DPP, the court made it clear detention must be reviewed and justified at all times. And in Hicks versus Chief Constable of South Yorkshire, the court said brief detentions at protests were okay, but only if they were truly necessary to prevent disorder and not just to make, life easier for the police. So what's next? Well, what if the police go too far? So if the police do misuse their powers or break the rules, well, the law gives you several ways to stand up for your rights. You're not powerless. So let's start with malicious prosecution. So if you've been prosecuted without good reason and the police acted out of spite or bad motive, you can actually sue them. But you'll need to show that the case ended in your favour, so you weren't convicted. You need to show that the police had no reasonable grounds for prosecuting you, that they acted with malice, not just by mistake, and also that you suffered some loss or harm like stress, loss of a job or damage to your reputation. So the case to know here is the Glinsky versus McIver case, and the court said here that you must prove both malice and lack of reasonable care. Next, false imprisonment. So this is when you are held by the police without any legal reason, and it doesn't need to involve handcuffs or jail. Even being told you can't leave, that could be enough. You just need to show your liberty was completely restricted and the police didn't have the legal right to hold you. An example here is R versus Governor of Brockhill Prison, ex parte Evans, and here a prisoner was held too long and the authorities were held responsible for false imprisonment. Some other remedies as well, so judicial review, you can ask a high court to check if the police acted lawfully and fairly. You've got complaints procedures, you can report the police misconduct to the Independent Office for Police Conduct. And finally, we've got Human Rights Act 1998. So you can take the police to court if your human rights were breached. So here's a quick recap table that you can look at, and you need to revise this to make sure you know the power, the law that concerns that power or connected to that power. You need to know the key rules and then also the link to the European Convention of Human Rights as well. And in conclusion then, police powers are essential, aren't they? They help prevent crime, they help keep people safe, but every power comes with a boundary, and those boundaries are protected by the European Convention on Human Rights and also by UK law. So if the police cross the line, there are checks, courts and remedies to hold them accountable. You don't just have to accept it if something's gone wrong. So remember this, restrictions are allowed, but only when lawful, necessary and proportionate. And that's the heart of this topic.